Hi everyone, this is just some quick feedback on the briefing paper. As you no doubt know by now, the end of term take-home papers are more in the nature of an exam rather than an assignment, so you don't get individual feedback on take-home papers or exams, although if you want to talk to me about it and discuss the matter, not a problem, book some time and we can talk about it. But because you don't get individual feedback, what we have to do is to provide you with feedback to the whole group about either exams or briefing papers. So that's what I'm doing here. And that was one of the reasons why I was very careful to give you a lot of feedback on your earlier assignments, because I realised that at the end of term I was going to have to be satisfied with giving everyone one big piece of feedback. But the comments here I think are relevant for everyone and hopefully will help you going forward. Alright, so in terms of overall impressions, I was very pleased with what I saw. I was very particularly pleased that I think everyone who submitted put in a video. And that was great. It's a very important skill, and it's important that you get used to the process of creating these kinds of videos. And the only way you do that is through practice. There's no magic solution to it, it's just through creating more and more and more. The first few videos I created were terrible, and I just kept rewinding and starting again every time I made a mistake. These days I guess I don't rewind when I make a mistake, I just make the mistakes, but a lot of it is about being comfortable with the technology, and that's why I put this in as a task here, and I was happy to see that everyone completed that. Now in terms of the actual paper itself, there's three things I really want to talk about. And I guess these are sort of three levels to think about in terms of assessment. First of all is the legal authorities and the law itself. Now that's the threshold level. That's the baseline that you set for your paper, and that's what you need to do to pass, is to show that you understand the law, that you've been keeping up to date with your readings, you've kept up to date with the workshops, and you know how the law applies. But there are another couple of layers on top of that. And this is something important going into your second year of studies. In the first year, we were much more inclined to throw marks at you for being good at spotting issues and spotting authorities and saying, here's the issue, here's the authority, match them up. But it gets more difficult. You know, once you think you're at the top of a mountain, there's another mountain ahead of you, and that's life. But in order to build more sophisticated legal skills, the next stage is to actually look at application. So not only, look, I've found what the issue is and here's the case, how do I apply it? And this is where we're looking at the credit levels, I guess, and maybe some of the lower levels of distinction, your ability to apply that. The level above that is that level of understanding. Not only just that's the law and how it applies, but I understand how the system works. And that again is something that is often something that you need to generate through practice, through understanding, through experience, either in a hypothetical sense, through doing lots of exercises in relation to law, through your understanding of the world from practical work experience, and all those other things. And admin law is one area where you can actually see that area quite starkly between someone who has a theoretical understanding of what happens when someone might take an appeal case in judicial review versus the big picture understanding someone gets of that, understanding how bureaucratic systems operate, how government operates, what's the role of accountability, what is the role of the integrity arm of government in that. So that's the sort of thing that we're looking for those higher level of grades. So we'll go through each of those a little bit in depth. The first is the legal authorities. As I said before, that's your baseline. That's to pass, you need to show that you've actually been keeping up with your readings, you understand most of what's going on, and you can find those authorities. So I'm going to quickly run through. I won't go through any of these in any particular depth, because obviously in the paper you didn't have space or time to talk about any of these in a lot of depth, but let's just sort of raise some of those issues as we go through. So in terms of the scenario itself, a couple of people were quite surprised at the idea that a local government could be susceptible to these kind of changes. And it's something that in the past never really happened, but is happening more and more often. We have seen mergers, we're seeing bankrupt local governments. Cities in the United States are going bankrupt at an alarming rate. And it's a really strange situation, because we assume this level of government, what we call local government, works like the other forms of government. But it doesn't. And this is where your constitutional law is very important, because there's no recognition of local government in the Constitution. It doesn't work the way that state and federal governments work. They work more like statutory authorities, and as such, when they go wrong, they can be taken apart, remoulded, changed. And again, this is happening more and more often. And this again becomes interesting, because we don't have very good rules for what happens. We suddenly have to try and patch things together, and that's the basis of this scenario. A city manager has been appointed who has the unenviable task of trying to keep things in equilibrium, but also fix the problems that have occurred through two radically different shires being merged together, each with their own problems, but having inconsistency between them. So a lot of the questions, a lot of the issues that came back had the spectre of bias hanging over the top of them. This idea of, when does something become biased, either because of the self-interest of an individual or a corporation that an individual holds, or because you've got different citizens being treated differently. And the formal answer to this really is that in law, it's a very, very high threshold you have to prove in terms of judicial review, in terms of bias. But in practicality, you want to avoid the appearance of bias, because that's going to lead to all sorts of other problems. So even if you're not being biased, if you appear to be biased, if you appear that you're self-interested and you're taking advantage of a position as a member of a council, that's a problem in itself. It may not be something that is a problem in terms of legality, that it gets challenged later on, although it might. But it's something that needs to be kept very much front of mind when we're looking at principles in terms of administrative legality and in terms of the integrity of these systems. And while the idea of corruption commissions we touched on very, very briefly, and we looked at commissions of inquiry, and it's not really raised in this particular problem, it does sit there on the back of the issue as well. That idea that even if a particular decision of a councillor or a councillor's involvement in a corporation that may be taking unfair advantage of their position may not be something that will be subject to administrative review, there are also all those commissions of inquiry that oversee corruption in public authorities, and they may get involved as well. So in terms of the administrative law issue, obviously there are many more issues here than you can cover in 1,000 words. And one of the important parts of this process was it was very overt, it was about prioritising, of looking at what were the important aspects and what should be focused on. So bias is something which you could be conscious of, but say that it's something that has got a very, very high threshold in order of proof. So it's really unlikely to be something that's going to create an immediate problem in terms of review of decisions. May, however, be something that contributes to overall decisions as to how the system is changed going forward. All right. In terms of the systems, there was a substantial issue here in terms of the merger of the systems, particularly the complaint systems and the information systems. And that was somewhere where the freedom of information laws become important. And it became in their situations where potentially the citizens could be not only flooding the bulletin boards and the message boards with inquiries, but they could then be flooding the FOI system with applications for information on where their complaints were at and what was happening with the conflicts that they were involved in. And you can just imagine, if the system's not actually being able to cope with a few phone calls, can you imagine then a stack of FOI applications suddenly appearing in the Information Commissioner, and suddenly then having to mobilise responses to those when you can't even answer the phone calls in the first place. So there's an issue there that pops up a couple of times in terms of FOI and in terms of the importance of fixing those administrative systems. And many of you quite rightly put this as number one priority, that until this gets fixed, the other things are not going to get fixed, and the other things are going to snowball. So that was a very important priority to pick on. There's no right or wrong answer for what priorities you gave, but it was important that you were able to substantiate why. And I thought this was one that was a very strong contender for number one issue. There's also the issue that stems on from that about the two different systems, particularly with things like the parking system. Was that enough to amount to being bias? Because one group of people had a more rigorous administrative system in one part of the one geographical zone. In another, we had the guy on his bike going around. Again, this is something that is very hard to meet the bar in terms of legal bias. And when you think about it, this is where the understanding, I think, comes in very importantly. Every administrative decision is biased to some extent. Even if you had one system within the same area, or one system of policing and enforcement, you always have to devote resources to one area or another. You know, if you had a very high-tech, modern parking inspector team of parking inspectors, they're still not going to be able to cover every single part of your territory every day. You're always going to be having to make decisions, which always means that on a particular day, one area is more heavily policed than the others, just by its nature. So this is something, again, it's a very high level of analysis, but thinking about the fact that all systems are going to be applied unequally at some level. So at what point do those systems become so unequal that it's legally objectionable? And obviously, the very high end, if we've got an issue where there's actual corruption, then you've probably got issues relating to fraud or bad faith. But what about in between? What about where it's just very unfair? Now, the answer there is really unreasonableness. And the Wensbury principle has always had this idea that some kind of unequal distribution of regulation, where some people are regulated one way, some are regulated another, can be capable of unreasonableness. And the case here, probably the most important case in this paper, is the Sunshine Coast Broadcasters and Dunn case, because that's the case where they actually spoke directly about unequal treatment, unequal regulation of different people. So there is at least a fairly strong argument here that if you've got one system of rules and they're applied differently in two different places, that would be considered to be unreasonable. Now, whether someone could succeed in a legal challenge on that is in many ways by the by, because you're not advising people about who are potential litigants. What you're doing is you're advising the person who's responsible for the system. And that's the person who you need to say, look, you need to have the same system for everyone. If we can't afford to have the drones going around with telemetry and Google Maps and things in the entire district, then unfortunately poor old Clive on his bike is going to have to cover the whole area. Or we're going to have to hire some more Clives to go out and cover the area. But it's a very bad look politically to have unequal modes of grossly unequal modes of regulation. And it's also a problem, potentially a problem legally. All right, just zooming, and I realise I've spoken a lot about that. Zooming through the rest of the issues, all the stuff relating to the decontamination plan and the corporation. Again, there's questions at the high end of bad faith, and there is an matter for discussion there as to at what level does self-interest of government bureaucrats, regulators and officers and councillors become bad faith. And we don't have enough evidence here about it being bad faith. And one of the kind of quirky things about local government is quite often local councillors are enriching themselves out of the decisions they make because they're generally business people in the local community. So it's part of they shouldn't be enriching themselves to the detriment of others or leaving others out. But theoretically, any good decision a council makes is going to enrich the councillors because they're going to make the area a better place. It's going to be a better place to live in, more productive, better for businesses. So we can't say that any kind of self-interest is going to be a problem for local government. But we need to be aware that it does look bad when a company that you have shares in is a company that is then not only making money, but in this case potentially breaking the law. And in terms of breaking the law, we really need to discuss here jurisdictional error, or ultra vires, if you want to use the old-fashioned Latin, I think cooler phrase, but cool is relative when we're talking about admin law, I guess. The issue around the so-called emergency work and the removal of weeds and billing people for it is a clear situation of jurisdictional error. And in many ways it's a classic, because it's a situation where someone has a bundle of powers to achieve a particular purpose, and they choose just to pull some of those powers out. So the ability to clear land and charge people for it is kind of a small part that's a necessary component of the power to clean up the toxic waste. Because if you can't get into the land and get into the property to clean up the toxic waste, you can't actually do your job. So it's kind of this, in some ways, a minor power that's necessary to achieve the overall aims of the legislation. But what happens when someone just tries to sever that particular power from the rest of the legislation and say, that's great, all we're going to do is clean up weeds and charge people for it, and that's what's happened here. So it's unfortunately not an uncommon situation, and it's where people don't understand the powers they've been given or the responsibilities they've been given, or they just think they've found a sneaky way out of it, where they go, hey, we don't have to clean up any toxic waste here, it's not going to cost us anything, we just become basically a weed clearing business, and we can make a lot of money out of this because we can charge people for it, whether they agree to us coming in and doing it or not. So, clear example of a situation where you need to talk about jurisdictional error, look at the purpose for which a power is granted, the way in which the purpose is actually being exercised, and whether there is evidence of that taking place. The other part of that is the issue of privative clauses and the attempt to try and move this outside of government review. Obviously, governments take those kind of clauses very seriously. The courts construe them very strictly. And they try and limit them wherever possible. And there's a whole chapter in the textbook on privative clauses, and those of you who read the chapter went quite swimmingly here and were really able to apply the things that were there. And finally, I guess when we're talking about the priorities, there was a red herring thrown in there in terms of the super mall. Because there's no real legal action here, the people have basically exhausted their legal remedies. There's no real clear case of there being an argument there was any kind of bias or wrongdoing in the decision. It's just that the residents didn't like the fact that there was a mall being built in their traditionally affluent area. The reason this is in here is to give you an opportunity to discuss the difference between legal compliance and the political aspects of the job. This is the sort of thing that would likely consume an inordinate amount of time from the administrator's point of view, because these are a group of people who are not used to having decisions go against them. They've had QCAT go against them and they don't like it. And this happens quite often, where people have actually been given natural justice, they've been given a hearing, they've been everything else, and they just won't accept the results. And they're in the local papers, they're on 60 Minutes, they've got signs and t-shirts printed up, they've got petitions going, and they are technically in the wrong. They've had their chance, they've had a fair hearing, and they've been told that they have lost. So this was not something you would be spending a lot of time on, but those of you who spotted the issue and spotted the political realities of the issue would be cautioning the city manager and say, even though these people don't have a remedy, they don't have a legal leg to stand on, they will consume all your time if you let them. So this issue needs to be handled extremely carefully, and it has to be something that is quarantined from the other issues and is dealt with probably very technically and very legally, and people need just to be told, you've had your day in court, so to speak, you've had your day in the tribunal, and you have to be satisfied with the response. They won't like it, they'll continue to protest, but if you keep engaging with them, you're just going to dig yourself in further. And that is, in many ways, the lot of local authorities quite often is a lot of the time they spend dealing with lobby groups, action groups, the old NIMBYs, not in my backyard, is very, very disproportionate to the time that's spent on actual administrative issues. Anyway, I've gone on quite a long time. The point I was seeking to make was there's a number of legal issues there that you could have pulled out. Obviously, admin law overlaps quite a lot with each other, different parts. So there's different ways of construing those. But those were the sorts of legal issues that were your baseline, that you could actually identify some of those, the most important ones, and provide a sense of priority. In terms of application, part of this also involved an understanding of how the law actually works. So you had to understand that the person you were advising here was a city manager. You were not advising clients. You were not advising on the likelihood necessarily of a case succeeding, or on evidential burdens or anything of that nature. What you were looking at was what was the administrative systematic consequences of these things. So it didn't mean you had to write a whole lot about this, but it meant that what you did write, you had to do so under the understanding that this had consequences for the way in which the city manager would then go and prioritise the business that they conducted, and not just say, here are the legal issues, there you go. So the people who got to get higher than and most people did this. Most people were able to apply, not just cite a set of citations and section numbers and cases. They could actually apply it to what the consequences would be. The more able you were able to do that, of course, the better your grades were. The highest level was about that understanding. And it was about understanding how government works, how local government works, to understanding how local government is not the same as state government, and in some ways the fragility of local government, and the importance of being able to manage a system where you have limited resources, and that you are not always going to win, that you're going to have to be able to provide the best possible thing by prioritising. So it was about the allocation of resources, the design of systems, being able to understand which systems were more important than others, and the ability to see beyond legal compliance and to actually look at the idea of good practice. And I was pleased a few of you cited the administrative standards and the good practice standards, and the good government standards, if that was a good thing to think of. But also to think that at the end of the day, it's not just a simple client-driven system as you might think of when you're talking about, say, torts law. Not that torts law is really like that anyway, because torts law today is all about insurance companies. It's really the law of insurance. The actual torts that you study in torts is kind of this tiny component of what torts practice is, which is largely around insurance organisations, really, and particularly compulsory insurance schemes. But here we're really talking about overall governmental systems and an ability to understand that good government is more than just not breaking the law. That good government actually has an ethical obligation and ethical standards in order to build systems that are strong and robust. And there's always a contradiction when you're in a crisis situation, as the manager is, because she needs to be able to keep things ticking over in the short term, with limited resources and limited time, but also needs to build things that are strong enough that you're not going to end up back in the same situation. So just briefly, I mean, the Super Mall situation, obviously that's going to be a lot of media coverage. This is going to be a lot of pressure on her, a lot from the state government who've appointed her. What's going on? These people are terribly aggrieved. There's not much she can actually do about it, but she could spend a lot of time focusing on that. Meanwhile, the complaint system's running out of control. The complaints are stacking up, and you've got this rogue company running around billing people for work that isn't supposed to be done. So being able to get a sense of the overall picture and to be able to say, you know, number one, fix the complaint system. You can hire some temps. You can put on some more phones. That's a reasonably fast thing to do. Number two, you've really got to deal with this company. It's rogue. It's running around. It's working outside the law. It needs to be stopped, and we need to actually try and stop them billing people. And then we'll filter back from there what other issues we think are important. Anyway, I've spoken about this quite a lot. Congratulations and thank you if you've gotten all the way to the end of this. Obviously, this is not a situation where I can say, here's the answer guide this is what you should have written. If you wrote all of this, you got 100%. And that's because that's not the way law operates. That's not the way law works. And going forward, things are going to become more and more complex. You had a set of training wheels the first year. We gave you a lot of opportunity to score points just from being able to say, this is the answer to the problem. But now, top of the hill, there's another hill behind it, there's another hill behind that, there's another hill behind that. I don't think that's a depressing thing. That's just the fact that as you're getting more skilled, the challenge increases. And this gives you an opportunity to step up and to meet those challenges and to show us what you've got. And I saw what you got for this, what you had to offer for this take-home paper, and overall I was very pleased. I was very happy to see that there was a good understanding of the issues. So there you go. If you need to have a chat about this some more, please make a time to see me. I'm going away for a couple of weeks, but happy to have a chat again when I get back in December, and either about this particular essay or just generally about your studies. If you want to have a chat about honours, or you want to have a chat about study or anything else, please feel free to make some time, and I'm more than happy to talk to you. Apart from that, if you're having a break over term 3, have a good break. If you're not having a break, you're probably going to be straight back into it really soon, and good luck with it.